it is designed to teach you how to read legal writing, how to write legal writing, how to understand it, draw meaning from it. So it doesn't teach substantive law. It teaches skills that you'll need to be a successful law school student and to be a attorney.
Wow.
So with that, we'll jump into the class. Okay. You guys should be seeing my slides, I believe, if I did that correctly.
Yes.
Yes.
All right, thank you. Sorry, as soon as I share my screen, my Zoom screen changes. So I want to see some of your faces here. Okay, so legal method. That's the class we teach your very first year of law school that teaches you how to think like an attorney, basically. It's an expression that describes the practice of law and how that requires methodology. You can't just jump into reading things. You have to know what you're doing. It's a process. So we're going to talk through 4 steps of this process today. All right, so the first thing is determining the legal issue. Sometimes what the layperson thinks is the problem isn't always the legal problem, right? The common sense problem and the legal problem aren't necessarily the same thing. So determining from a set of facts if there is a legal question, and if there is, what is the precise legal question? Then when you know what the question or the issue is, you have to go out and research. You have to find different sources to teach you about how the law has interpreted these things and different terms and how those interpretations would apply given a unique set of facts, right? So we have to do that research. Then after we've researched and educated ourselves on topics, we then have to apply the law. And the way it applies to different sets of facts can be very different. Like a fingerprint, sets of facts are always going to have variances. And so we have to know how is the law going to apply given the way these facts vary from prior cases. And then finally, once you have all of that information, you know you're pretty well versed on how the law is going to apply to this set of facts. You have to communicate that, be it in orally or in writing. You have to have a way to let your audience know what your analysis of the law is. And that's the process, right? We're going to briefly, there's a lot more to these concepts. We're going to briefly touch on these in the next hour. So let's start with this legal issue idea. Legal issues derive from a set of facts. By practice and discussion, you're going to start to develop a sensitivity to different facts and how they might implicate a law. So let's look at a kind of absurd set of facts here. So here we got this story about Albert. One evening, Albert was told that his estranged wife Zola was having overnight male guests in their residence. He immediately stormed out of the sleazy saloon where he'd been all evening and drove his car wildly to the residence. He forgot his key, so he broke down the front door, ran into the bedroom, and fired 3 shots at the ceiling to get their attention. Zola, who was in the bed alone, was hit by a bullet that ricocheted off the light fixture and died instantly. What words in this was what we call a fact pattern? What words in this fact pattern indicate potential legal issues? Lucy.
When he shot bullets up
Okay.
toward the ceiling. That's
Okay,
one
so
of them.
the fact that he shot, what legal issue do you think that might implicate?
It might be assault or battery.
Okay, all right, good. Any other thoughts? What other words indicate legal issues?
Maybe broke down the front door, breaking and entering.
Okay, the fact that he broke down a door, entered, okay.
The
fact that he was leaving the saloon and drove home.
Doesn't live there.
Okay, let's start with the leaving the saloon and drove home. What legal issue might that implicate?
Intoxication.
Drinking and driving.
Okay, right, we might have a DUI. And somebody else said, there were 2 of you speaking at the same time. What was the other comment?
Oh, sorry. I said, this is his estranged wife, so he didn't live there. So him storming into the house.
All right. So
Okay.
that may be, right, breaking and entering into your house, probably not so bad. Breaking and entering into somebody else's house, that might, right? That's good. That's the type of thing.
But he did have a key.
Okay.
It
He
did
had
say
a key,
that
but he forgot it. So, right. Okay. So there's all these sorts of words that might implicate things. And there's some of those that you've touched on, and there's some others, and we'll come back to this. So let's look at, once we know then Once we think we know, I don't know how to erase these lines, so try not to make the marks. I don't know how to take them off without stopping, and we really don't have time today. Okay, so once we think we know what the legal issues are, we have to start researching the law. Now, when you start at law school, you're not going to start with just having to go to books and go to research databases. In the very beginning, what we mean by researching the law, it's we're going to give you the cases. We're going to have found them for you. We're going to give you statutes. We're going to give you cases for you to read, and you have to know how to pull out significant meaning from those documents. So let's look at the different types of law very quickly. We've got what we call statutory law, right? Constitutions, you've got statutes, codes, and ordinances. Those statutes, codes, and ordinances then usually are implemented through what we call administrative law. So we might set up regulations that make sure that different codes are properly enforced, right? All of these are written statutory laws that we can look to for direction of what the law requires. Then we've got common law. Common law is a series of judicial opinions. It's what the judges have written. So it's still law, but it's a different type of law. Usually, common law is interpreting or applying meaning to statutory law, right? How the courts have said, okay, our Constitution says freedom of speech, but what does freedom of speech really mean? We can look at case law to look at what the courts have said freedom of speech really means, right? That's our common law judicial opinions. So let's look at the statutory law for just a second. I'm going to put up, these aren't actual statutes. I've shortened them, made them very simple for our purposes today. But let's assume that these are the way that our codes have defined burglary, murder, and driving under the influence, all of which you guys recognized from the fact pattern as potential legal issues, right? Laws are written to incorporate of different elements. They're comprised. These statutory laws are comprised of elements. Each element is usually an essential requirement. In order to say somebody broke this law, you have to demonstrate every element was broken, right? So we have to be able to read a statute and divide it into elements. So let's just look at burglary. What do you think one of the elements of burglary might be?
Breaking and entering.
Okay, we've got breaking and entering. They might be one thing, they might be two things. What else?
At night.
Okay, at night. That right, we might have to look at what time of day it was. It might be something different if it wasn't at night. What else?
Someone else's dwelling.
Okay, if it's your own house, you got to fix it, but right? Okay, anything else? Lucy?
Intent to commit.
Oh,
Oh, your hand's still up from last time.
oh,
Okay,
I apologize.
somebody
Apologize.
said intent to commit a felony. So you can't just break and enter because you want to throw a party, right? There has to be an intent to commit a felony. So we can look at that. Oh, sorry, I jumped ahead here. There we go. We can look at that to determine what the different elements are. Each individual element is probably going to have cases that define what it means and how it's been applied to different sets of facts, right? We can do the same thing for murder. Murder is going to have to be a killing, but it's not just a killing. We're not going to call it murder when it's a cat. That's a different crime, right? It's a killing of another human being. And you have to have done it with the intent to kill or with callous disregard for human life. Right? So there's different elements to these things. Driving under the influence, you have to be driving and you have to be impaired, but it can't just be an impairment because maybe you have a medical condition. It's an impairment caused by intoxication, right? So each of these represents a different element of the law. Now, with that in mind, do we notice any more words that might indicate legal issues from our fact pattern that we didn't mention earlier?
The word wildly.
Agreed.
Okay. Wildly. Why do you think wildly might indicate an issue?
It indicates an emotional state prior to the act.
Okay. Which one of our elements from one of our laws implicates an emotional component?
Murder.
Okay, maybe, right? So maybe it's that callous disregard for human life. So, but did the wild driving end up in killing another human being?
No, it did
Okay,
not.
so this is a good demonstration of when one of the elements may be met. Maybe, we don't know for sure. We'd have to look at how wildly do they have to be driving, but is driving wildly enough to constitute callous disregard for human life? But even if we say yes, and that element is met, there is an element missing of a killing, right? So we're not going
Right.
to charge him with murder for driving wildly.
Exactly.
What
He
and
was-
what other words jump out as maybe applying to some of our elements?
He had a
Fired
good
3 shots. Oh, I apologize.
Okay,
At the
Kieran, go ahead.
ceiling. Yes, so fired shots at the ceiling to get attention.
Okay.
So he didn't
What element does
clearly
that go to?
fire like the disregard for value of human life. Although he didn't point it at her, that's what it led to. His actions led to that killing.
Okay. And that's another good example. We've got intent to kill. He
Mhm.
didn't have the intent to kill, right? He did it
Right.
just to get their attention. So the necessary intent to kill wasn't there. But this law allows two different types of intent. You do have to have intent, but from intent, it branches out. It can be either the intent to kill or
Mhm.
that callous disregard for human life. And this would probably
Right.
qualify as that. Any other words jump out at you?
Question. Could you then bring in the element of battery if the intent was to startle them almost as if like a prank or to get their attention since they did cause harm?
Yeah, maybe, right? If you're looking at murder, you want to charge, let's say you work for the DA's office, you want to charge him with murder, but maybe you're afraid one of those elements isn't met. You can look at a lesser charge to find out if all the elements there are met, right? So possibly. Any other words in our fact pattern seem to indicate one of these elements?
I'm sorry, did you call on me? My internet is very unstable.
Oh, I haven't called on anyone yet, so.
Okay, sounds good.
Broke down the front door, ran into
Okay.
the bedroom.
Okay, let's go with broke down the front door. That one's a little easy. What element does that go to?
Burglary?
Burglary.
Okay, it goes to the law of burglary, but what element?
Oh, to someone else's dwelling.
Okay, or breaking and entering, right?
breaking and
Probably more
entering,
of the
sorry.
breaking entering, the broke down the front door and ran in. So it's not enough that he broke down the front door. It has to be both breaking and entering, right? So the running in accomplishes the
right.
entering in. And somebody mentioned earlier that it was his estranged wife. So maybe it wasn't his home. Did they still dwell in the same home? Somebody else mentioned, but he had a key, but he forgot his key, right? So does having a key, think about it this way. Does having a key, even if you don't live there, maybe you live, he got an apartment across town, but he still has a key because he used to live there. Will the case law support that that's his dwelling still, even though he has an apartment across town? Does that still make that his dwelling, or is that his wife's only dwelling, the dwelling of another, right? So that's where we would have to look at case law. We'd have to look at common law to determine what is meant by dwelling of another. If you used to live there and still have a key and sometimes visit, does that still make it your dwelling, right? We would have to look at what case law says.
In
What
their
about,
residence? Doesn't
sorry,
that
Lucia, go ahead.
the words in their residence, doesn't that indicate that it was his residence as well?
It might, right? So that would be looking at what the meaning of those words mean. Yeah, it could. Any other
Mrs.
words
Howard?
jump out as going to an element?
I was gonna say, if nobody said already, ricocheted.
Okay. How so? What
Because-
element does that go to?
Well, it sort of goes to murder, but it sort of shows that it wasn't intentional. I just don't know if it was a callous disregard. It kind of seems like it was negligence.
Okay, we would have to definitely dive into what case law has said about callous disregard, right? How has the judges, how have they interpreted callous disregard? If you are definitely aiming it away from a person, is that is that enough to say it's not callous disregard anymore? I don't know. We would have to do that research, right? We would have to read that. But the fact that it ricocheted off, that he wasn't pointing it at her, that might help him. It might not. Anything else?
Has anybody?
If he,
Question.
Okay,
If he-
Deja, let's go with Deja first.
I don't know if it goes to any of the specific elements that we're addressing at the moment, but has anybody addressed the potential hearsay issue that he
thank
was
you.
told
That was my question.
Okay.
about
Well,
this?
hearsay is going to be a rule of evidence. We're not going to get into that today. That's going to be, but I mean, it could potentially, right? It could potentially be a problem if we end up in court. Right now, we're just trying to see, do we even have enough to try and charge him, right? Let's think of it from that point of view. Not necessarily can we get it into court and prove it. Do we even think we have enough to charge him at this point? What about the idea that he was at the sleazy saloon? Does that matter? Does that have any legal significance at all?
Yes,
Why?
it does. Because he could have been potentially dreaming. I mean, not dreaming, drinking.
Okay.
And we don't know how much he drank or
Okay.
if he drank anything.
So what else do we know from this fact pattern about this idea that he may have been drinking?
It says that he was there for a long time.
Okay.
And he was
That
driving
ends up being
wildly.
important, right? Now,
Yeah.
again, can we definitively prove that he drank while he was there? No. But just looking at these facts, we can probably go with DUI, right? We can think he was probably drinking, he was there. What else? What else might indicate this?
The combination of sleazy salon and drove his car wildly indicates intoxication, possibly.
Okay, it might, right? The fact that he was driving wildly. Now, that may have been because he was upset. It may have been because he was drunk, but it could go to that.
The fact that he was
What about
told
the
this.
idea that he immediately stormed out?
Mm-hmm.
Why is the word immediately potentially legally significant?
Because he may not have even been thinking. And if he had an intent to kill, he had to reflect. If he,
Okay. It could go to his state of mind regarding
think it
the
would,
type of
yeah.
intent needed for murder. What else could this indicate? Immediately, that he immediately stormed out. What other legal significance could we pull to that? Did he sit in the saloon and have a cup of coffee and make sure that he was okay before he left?
No.
It was a
no.
rash decision.
Right? So he was spending all night, he spent all evening in the saloon and immediately ran out. So we know that he didn't try and wait till he was no longer under the influence, right? So this might also go to the DUI, the impairment part, right? Was he actually impaired when he drove? It might help support that. It's a fact that might indicate he didn't wait until he was okay to drive. So that's, again, kind of a silly fact pattern, but it demonstrates this idea of pulling out legal issues. Now, remember, legal issues aren't going to be so broad as did he commit murder? No, usually the legal issue is about the elements, right? Was there a killing? Yes, his wife died. So killing is going to be a lot easier to meet, but we may have to look at the intent a lot heavier, right? So our legal issue isn't did he commit murder? It's more precise than that. I tell my students, you're broadening from murder down to what elements are questionably met. Did he have the proper intent? Did he intend to kill her, or did he have callous disregard for human life? That's what we're going to have to start researching. So looking back at what we said here, when you determine the legal issue, your next step then is to research the law. You want to be researching cases on probably callous disregard, right? That's most likely the type of intent. If he had the right intent, that's probably the intent he had, was callous disregard for human life. So we have to do some research to find out what the courts have said about callous disregard. Is it enough to just fire a gun? Maybe it doesn't matter whether you're aiming it away from people or not. Maybe just firing a gun is callous disregard. Maybe firing a gun but purposefully aiming it away from people is not anymore. Well, we'd have to find out what courts have said in similar, they're not going to be the same, but in similar fact patterns where these types of actions occurred. What did they say about it reaching the level of callous disregard for human life? That would be our research. Then we get to this point where we have to communicate. This is quite often the hardest part. because you have to communicate it as to each individual element, right? So here it is or is not burglary because he did or did not break in. He did or did not enter in to someone else's dwelling, right? At night. We've got all these different elements that we have to write about. So I want you to just pull out a paper, pull up a Word doc real quick. I'm just going to give you a couple of minutes to try and write about burglary. Just focus on burglary given our fact pattern. Can you write an answer to whether or not it was burglary? And here's our fact pattern if you need it. Right, usually in class, I'll give you a little bit more time, but because we have a short time frame. What I like about having you try and write it out is you get a idea of it's not as easy as you thought to put it into words. Fixing it in your head is one thing. Finding a way to
Yeah.
actually communicate it, that's a whole nother skill. And so here's the type of answer I would be looking for, something along these lines. Albert did break. So I'm just going to look at break. Did break into the house because he broke down the front door. So I've looked at just break alone, just the element of breaking. Did he actually commit a breaking? Yes, because he broke down the front door, right? Albert did, oh, here we go. Albert did enter because he ran into the bedroom or into the house, right? So I've attached facts to that element of entering. However, it is not the house of another because he had a key, he just forgot it. Again, that might go a different way depending on our research, but you know. However, it could have been just his wife's house because they were estranged, and we know he is driving to the residence instead of their residence, right? So we're pulling in those facts that some indicate it might have been his house, others indicate it might not have been his house.
What about the gun?
Well, the gun really doesn't have much to do with burglary. That would go more to the murder, right? We're just looking at burglary right now. Well, it might go to the felony part, but we'll get there.
Okay.
It was at night, because that's our next element. He broke in, he entered, and the house of another, maybe, maybe not. And it was at night because he left the Sleazy Saloon in the evening and drove wildly to the residence. So we know he left. He was there all evening. He left in the evening, maybe even throwing in immediately. He immediately left. We know he didn't wait till, 6 o'clock in the morning. However, he did not enter with the intent to commit a felony because he only wanted to fire a warning shot, not kill anyone. And that would depend on whether or not firing a warning shot is a felony, right? Which is a whole nother thing we would have to research. But for today's purposes, we're going to say, let's say it's not a felony. The warning shot doesn't quite reach a felony. It might, but we're just, for arguments purposes today, say it doesn't, right? But that's how you would have to communicate that sort of an answer. You have to look at each required element and discuss whether or not that element has been satisfied under the law or not. And in order to do that, sometimes, and most often than not, the answer is yes, you have to go and do some research. Because what we think evening means may be totally different than what the law or the courts have defined it as. Is evening from dawn till dusk? Is evening from midnight till 5 a.m.? Right? When does evening start? When does evening end? We would have to figure that out if we thought his time frame may have been on the border of evening or not. right? So we have to actually look at what the case law has said in interpreting the meaning of some of these words. But we have to take the law, divide it into elements, and then discuss why each element is or is not satisfied legally, given the facts that we have. So now that's our first half of class. Now, hopefully you read the case that was assigned, our daily, the daily case, I believe. We're going to take a look at judicial opinion. So we're switching gears now, but it's under the same idea. What we've talked about so far has been statutory law, right? That idea of we have these statutes that just give us the words. Well, sometimes, as we've discussed, those words, those elements, have deeper meanings that courts have applied to them. And that's where common law comes in. So we're going to take a look at some of the wordings of battery through the meaning of the words of battery through the daily case. So let's start with just some of our simple questions. What happened in Daly? Why? Why are these people even in court?
Brian Daly, who was 5 years old, and his mother visited her sister, Ruth Garrett, in Ruth's backyard. While Ruth was inside the house, Brian moved a lawn chair sideways a few feet to sit on. He discovered his aunt, Ruth Garrett, was going to sit down where the chair had originally been and hurried to put the chair back, but it was too late. Ruth Garrett fell to the ground, fracturing her hip and sustaining other injuries.
Okay, so we've got this idea of we've got a 5-year-old boy, and he was accused of battery because he pulled out a folding chair. When she was trying to sit down, she was injured. Very good. Okay.
Thank you.
So again, we've got this fact pattern. Lawyers have to identify the law and specifically the elements implicated by the facts, and then determine how these facts will be defined or interpreted. So given these sets of facts and the case, what do you think ended up being the ultimate issue? Remember how I said earlier, we start broad with this idea of murder and we narrow it down to what was implicated in our previous fact pattern. We would have had to have researched callous disregard for human life. What is it here precisely within battery, Kieran, that we think is at issue?
I think the issue is intent.
Okay.
Here that we go, and it breaks it down. The case does into, I believe, like 2 different ways that the defendant could show intent through his actions.
Yeah, very good. Okay, and we're going to get to those. All right, very good. So here's just pulling some language from the case. If you have yours out, I don't know exactly what page this is on, but this little screenshot down here is where the case identifies it as being battery, and it gives us this idea of the intent, like Kieran said. What's the intent? They started with battery, but they even went further, right? The intentional infliction of harmful bodily contact on another. So now we know one of the elements of battery is the intent to inflict harmful bodily contact on another. We know that's one of our elements, but what does that really mean? That even, like Kieran pointed out, ends up dividing into 2 different types of things. Okay, who filed this lawsuit?
Ruth Garrett filed the lawsuit.
Okay, and who is defending the lawsuit?
Sister.
Naomi Garrett.
Okay.
Brian Daly.
Right, the mom, the kid, we're going to define it as the 5-year-old boy, Brian Daly. Obviously, his mom probably did a lot of the footwork, right? But ultimately, Daly is our defendant and Garrett is our plaintiff. Who won at the trial level?
Brian Daly.
Okay, why do you say Brian won?
Because they couldn't actually prove that he intentionally moved the chair to hurt Ruth Garrett.
Okay. Anybody else? That's good. There's a little bit more. Anybody else got some more insight?
It was dismissed
Paulina?
because
Sorry. Oh, okay. All right. And somebody else. Thank you. I didn't see who else was talking. It was dismissed, which means they never even heard the case, right?
Oh.
Ruth said, I got hurt. And the trial court said, too bad. We don't think there's a legal problem here, right? So ultimately, the defendant ended up winning by default, sort of. Didn't really even have to defend himself because it got dismissed at the trial level. And that's where we see this sort of language, right? The plaintiff appeals from a judgment dismissing the action. So the lower court didn't actually reach a decision, and she thought, I should have my day at court. So she appealed the motion to dismiss, right? Which had been granted. Who wins at this appellate level?
No one.
Okay,
Remanded
why do you
back to
say no
trial.
one, Johnny?
The case was remanded for clarification. They found no merit in the plaintiff's contention for the judgment of $11,000 in her favor.
Okay,
And
what was lacking in merit? Why did they remand it? Usually they remand when they need some clarification, they need a question answered. What ultimately did they want answered?
whether Brian had the knowledge, what is it? The knowledge of substantial certainty that the harmful bodily contact or apprehension would occur
Okay,
based on
very
what he
good.
was based on his action.
Okay, and that's where we see
Good,
this.
Johnny.
We remand for clarification on the issue of whether Brian Daly knew with substantial certainty that she would attempt to sit down where he'd moved the chair. Now, think back what we already know. We know battery, and we know battery requires intent to commit bodily harm on another. Where does this substantial certainty come into play?
Apprehension, under apprehension.
Okay.
And by knowing that if she was to fall, that she would be harmed
Okay.
if the chair wasn't there.
All right. So you have to either intend for somebody to actually get hurt, or sort of like this callous disregard for human life idea, you have to know, even if you don't want them to get hurt, you have to know they probably will, right? That sort of idea, substantial certainty that that harm might happen, even if you don't specifically want them to get hurt. Okay, so battery somehow ends up with this idea of knowing with substantial certainty that she would sit there again. So why does the court make the decision that it makes? Now, remember, it made the decision to remand it for clarification on whether he knew she would try and sit down again. Why did they make that decision? Johnny.
I'm just going to read what I wrote here. Without Ruth Garrett, and why did Ruth Garrett not testify as to why she herself fell? Was that a normal thing?
I'm not sure. Maybe her attorney thought that she would be a bad witness. I don't know.
So without Ruth Garrett's own testimony as to how or why she fell, and unwilling to accept the testimony of the only eyewitness, which was her sister, the court instead adopted Brian's version as evidence, and everything is sort of based off of that, which means that whether or not Brian's action in moving the chair constituted a battery ultimately relied on the boy's knowledge of such an action causing with substantial certainty a harmful or offensive contact thereof, and with no proof from the plaintiff that Brian moved the chair while she was in the act of sitting down, and Brian having no such knowledge required to infer intent, there was no wrongful act on his part.
Wow.
So the trial court didn't actually do enough diving in to find out about things. So this appellate court is left with a incomplete record of sorts, right? Where they can't determine what his state of mind was, what he knew at, or should have known at the time. So they were unable to determine if he had the intent to batter. And again, we know battery, one of the elements of battery ultimately leads us to the idea of that he knew with a substantial certainty that she was going to sit in that exact same spot again. And here's where we pull that from the case. The case should be remanded for clarification of Brian's knowledge about intent. What could be inferred about his intent? We don't have enough information to make an inference about his intent, so we have to remand it back for that clarification. So then we get this idea. That's where ultimately from the case law, from the decision of the court, it ties the idea of knowledge to a substantial certainty that she would sit down again. They tie it to this intent, right? That's where we know battery requires intent. Intent can be inferred when there's knowledge to a substantial certainty that the plaintiff will sit in the exact same spot where you removed a chair, right? We know that that's enough. Given Daly's case, you can prove intent if you can establish that he knew she would try and sit down right where he removed the chair.
Yep.
Okay. And that goes back to what lawyers have to identify, right? We have to identify whether he committed a battery, but I tell my students all the time, it's never that broad. It's not even so broad as intent, right? Because we know intent means he wanted her to get hurt, or even more narrow, he knew with substantial certainty that she'd probably get hurt. And so that's what we ultimately have to to determine, did Brian Daly know to a substantial certainty that Garrett would try and sit there again and then get hurt because her chair was gone. And this is a helpful case for that because it shows we don't have enough to determine that. We don't have enough information to determine what was going on in that boy's mind, right? So the act must be done for the purpose of either causing the contact or with knowledge on the part of the actor that such contact or apprehension is substantially certain to be produced. Even if you don't purposefully intend for that specific contact, you don't intend for her bum to hit the ground, but if you know with substantial certainty that it will happen, that's enough for the right kind of intent for battery. And that's where we can pull that out from the case, right? That they're citing to what we call the restatement of torts, where they're putting that information in there. So in order for an act to be done with intent of harmful or offensive contact, the act must be done for the purpose of causing the contact or with knowledge to substantial certain that contact will be produced. And we see the language again here. Unless he realizes to a substantial certainty that the contact will result, then he doesn't have that kind of intent, the proper intent. Paulina, did you have a question or comment?
I have a comment. It states on the beginning of the case that he hurriedly, once he saw that she was about to sit down, he hurriedly got up and tried to push the seat towards her to prevent her from falling. So he did realize, but he didn't have the intention of her falling.
Okay. So where does that begin? Why do you think the court didn't have enough information there? That seems to indicate he knew. So why would the court need to remand it back in light of that fact that he was trying to put the chair back when he noticed her trying to sit?
Did he know at the time he moved the chair that she was going to sit?
There you go. It's at the time of the battery. The alleged battery occurred when he moved the chair. So we have to get inside his head at the time he moved it. Now, I think the fact that he noticed she was trying to maybe sit back down might indicate that he should have known. It might be a supporting factor, but it's not enough, right? They need to get in his head at the moment that he moved it. Rachel, did you have a question or comment?
I do. I was wondering, you keep talking about getting in his head or figuring out what was going on in his mind, but how does a court find out what's going on in a 5-year-old's mind to defend him? How would you?
It's a good question, right? And that's where they're going to want him on the stand. They're going to want to ask him some questions about that day, about what he was thinking at the time, right? They're going to want to find out a little bit more, and then they'll have to draw inferences. They're never going to be able to wave a magic wand and prove exactly what was in his head. We can't even do that with adults, right? You take the stand and you say you'll tell the truth, but we never know for sure who's actually telling the truth. But that's one of the reasons why the appellate court remands it back. The trial court is what we call the finder of fact. They're going to look at the people who are on the witness stand. They're going to listen to them. They're going to see if they're sweating bullets, if they look nervous, if they look truthful, right? They're going to weigh all sorts of factors when they make their decision. The appellate court doesn't make a decision about facts. And what he was thinking at the time, that's a question of fact. And so we have to let the trial court make that decision. So the appellate court's going to remand it back and say, you do your job and find out the information that you need to find out. Before you dismiss this, we have to look at the intent piece. And you kind of overlooked that. But that's a good question, right? And that's a skill. That's a whole nother class from now, right? Proving things on the stand, that's a whole nother class. So now we've got this rule from this case. Battery requires intent. We also have a rule about intent. Intent can be inferred from certain facts, and one set of facts that can help us infer intent is not set of facts, but that intent can be inferred if we can establish that there was knowledge to substantial certainty that the plaintiff would sit there again. Now, this is not what I call a generic rule that can be used in every battery case. Some battery cases have nothing to do with somebody sitting down. right?
Mhm.
So
Right.
utilizing those words, the plaintiff would sit there again, doesn't help us make this a generally applicable rule that we could use in another battery case. So how could we rephrase this?
Maybe that's the place she always sits.
What was that?
What's the chunk we're wanting to
You want
rephrase
to
again?
take out this part right here, right? Think
Okay.
about the rest. It's all the rest of it is generally applicable. You could take this to another case where some guy punched another guy in the face. That's a battery, right? When you punch somebody right in the face, pretty clear battery. We could take the rest of this and apply that to that set of facts, except for the end, right? We can say battery requires a specific kind of intent. That type of intent can be inferred
There
if
is knowledge
can
to a
establish knowledge
substantial
to substantial certainty that what? Sorry, I cut somebody off.
Yes, that the defendant knew his action would cause harm.
Okay. Knowledge to substantial certainty that their action would cause harm. That's one way we could word it, right? It's cause harm, or it could even be offensive contact, right? That they knew to a knowledge to substantial certainty that their act would cause harmful or even just offensive contact. Maybe I don't punch you hard enough because I'm a weakling to hurt you, but I offended you when I hit you, right? That might be enough for battery, but it also can just be apprehension. It doesn't have to be absolute crystal clear. I 100% know that that harm is going to happen. It can be an apprehension of that harm possibly happening, right? And that's the rule that we've pulled from Daly. That's what we know about the right kind of intent for battery. You don't have to absolutely 100% want and know that that person's going to get hurt. It can be enough that you have knowledge to essential certainty that they probably will get hurt because of your act, right? That's enough. And we know that now because we read Daly. Okay, so here they said, and we kind of talked about this, from the facts that they had, it was unclear if the defendant had the intent, that right kind of intent, that knowledge to a substantial certainty that harmful contact was about to happen. And here's what we know. The trial court had already determined he picked up a chair and he moved it to another location. He noticed that she was going to sit down after he'd moved the chair, right? And he tried to get it back in place. And then she fell and was injured. But we still don't know what his mindset was when he moved the chair. We know what his mindset was a few moments later when he noticed she was going to sit down again, but not at the time he moved the chair. So the court wants more information about that moment before they make a decision about intent. Okay.
I have a question.
Yes.
About what you just said. So, does it say anything about his intent if maybe he was at her house on a weekly basis and he knows her well and he knows that she's always sitting there versus a kid at a park who's never met her before?
Okay, I think that's a great question. And your professors will, when you dive into cases like this, your professors will often skew the facts a little from the case and go, well, what if this had happened this way? Would that change things? So I want you to answer your own question, Danielle. Why would that matter or not?
Oh, I mean, I have no idea. I guess I just feel like if he's familiar with her and her habits, even if he is 5, if he knows that she's always sitting in that chair, maybe there was some intent.
Right, it would definitely, I think, I shouldn't say definitely. I do think it would support the inference that he should have known harm would happen, right?
Okay.
I don't know if any of you are Big Bang fans, Big Bang Theory fans. Sheldon always sits in the same spot, right? That's one of the big jokes in my family. So if you moved his couch right when he was about to sit down, like that's the first thing that came in my mind when you asked the question was, yeah, obviously any of his friends who moved that couch would know Sheldon was going to come back and sit there because that's the only place in the apartment that Sheldon ever sat. But Somebody else who's just moving it because they want to rearrange the furniture had no idea that that's the only place he ever sat. Maybe they wouldn't have knowledge to a substantial certainty. So we would have to go and look for cases, right? As an attorney, you would want to go and find cases, especially if we're trying to either, oh, well, that's on a whole other thing. But you'd want to go find cases that show, have the courts used that sort of personal knowledge as a way to either prove or disprove intent. If you can find knowledge of patterned behavior showing up in other cases, and the court's actually using that to say, because they had knowledge of this patterned behavior, we're going to say, yes, they knew, right? That's going to rise to the level of knowledge to a substantial certainty because they had knowledge of this patterned behavior. If we can find that, well, now we've got what's called precedent, meaning a past case has already used it, right? And now we can tell our court, you have to use this information too. This is helpful information that it, defines, helps us determine whether or not an element is met or not. Johnny, did you have a comment or question?
Yeah, I was just wondering, as far as the knowledge, like, would someone be able to argue, like, let's say Brian moved the chair while she was in the act of sitting down, so he had the intent of her falling to the ground. However, his knowledge of to what extent that bodily harm would be, as in, because when you're a child and you do this with kids, it's just a little plop and a laugh. But for an adult falling from higher, she breaks her hip, but he doesn't really understand that or know that. So would he still, what does that come into play?
So that's a good question too. My mouse is not working with me here. I think I've got too many things open.
He has the intent of her falling, but he lacks the knowledge of to what extent, bodily harm, not $11,000 of
Yeah.
harm would be
So are
done.
you guys seeing a new screen on top now with my case, some
Yes.
yellow highlighting? Here where it says the only circumstance where Brian's age is of any consequence is in determining what he knew.
Right.
And that's
Like
what I
his
meant. What do you think?
experience.
And what do you think that means, Johnny? What do you think the court is saying?
Sort of what I'm getting at with his experience with someone falling out of a chair or seeing it done as a joke and it being funny, just up to that point in his age.
Yeah.
Would the court compare Brian to another 5-year-old and what that 5-year-old would do in that particular situation?
I think that's kind of what they're saying here, right? We are going to take his age into account, but only to get inside his head and determine what he knew about his consequences at the time, right? That's the only reason we care that he's 5. He doesn't get a free pass because he's 5, but what did he know about her getting that harmful or offensive contact? Now, I don't think it's enough probably for them to say he only wanted her to fall and be embarrassed, because that's still offensive contact. It doesn't have to be harmful. So he doesn't have to know that she'll probably get hurt. He just has to know that she's going to fall and her bum hit the ground. So would a 5-year-old who moved a chair know somebody else? They're probably going to come right back. She's just getting a deviled egg. She's going to come right back and sit down, right? Would they know? Would a 5-year-old have reason to know that the aunt's going to come and sit back down again in that same spot? Or are they going to say most 5-year-olds don't know? But they have given this instruction to the lower court. You can kind of take his age into account, but only regarding what we're going to hold him to have known at the time.
He was moving the chair while she was in the act of actually sitting in it.
Yeah, but he didn't, the first time he moved it, she wasn't sitting down.
Right.
She wasn't in the act of sitting. Now, if she was, maybe they wouldn't have needed to remand it. Maybe if he only stood up, ran over, and moved the chair while she was sitting down.
While she was about to sit down, it's different.
Maybe now they're going to say we have enough information, right? He knew he should have known her bum would hit the ground. But because he moved it while she was not in the act of sitting down, that's why we're remanding it back. We're going to let the lower court, maybe the appellate court knows what they're thinking. They know what most 5-year-olds know. But again, they're not the finder of fact. That's not their job. They have to remand it back for that fact to be determined by the lower court. Melissa.
I just had a question. If the lower court already decided that they had accepted the testimony of being the fact that he was only intending to move the chair back to help her, if in establishing intent to help, if he's trying to help, then doesn't that establish the fact that he was not intending to do any sort of harm generally.
Well, it might support that. Maybe he changed his mind. Maybe halfway through, maybe pulling it out as a prank initially, but then halfway through when, oh, Auntie Ruth is going to be so mad at me, and he changed his mind and tried to put it back, right? I mean, we don't know. And again, the appellate court is not going to get into their minds and try and determine that. If they don't feel like they have the facts to make the call regarding a finding of fact, if it hasn't been determined by the lower court, they have to remand it. The lower court has to make that determination. And they were a little hasty in their ruling on the motion to dismiss, and they didn't find out about this fact. They thought they had enough, but the appellate court saying, no, there's still too many unanswered questions here. So you guys have been great. This has been a wonderful class. I'm so excited for you to be some of our incoming students. I appreciate your participation. Again, this is a little bit different from what you're going to see in some of the other mock law classes because they're teaching more substantive law, and I'm more or less trying to introduce you to some of the skills. And this is a very surface level, right? Things are going to get much more complex as you dive into law school. But this is a flavor of one. This is about the first hour of the very first class that I teach during orientation week. And Diane, I'm going to turn it back over to you.
Okay, Professor Howard, thank you so much. Before we have you sign off, could you just share with us, I know you attended San Joaquin College of Law and you were valedictorian in your class, top of your class. What parting bit of advice or tip do you have to these incoming students?
Don't underestimate either yourself or law school. So if you get admitted, you have the skill to do it. It will be hard though. Just because you have the skill does not mean you don't have to put the work in. So I would say take law school seriously. It will be the hardest academic rigor that you'll experience, that you've probably ever experienced, assuming none of you are surgeons at this point. So it is challenging. But again, I would echo at the same time, don't underestimate yourself either. The ability is there, but you're going to have to put some hard work in, time and effort.
Awesome. Thank you so much, Professor Howard. It was wonderful as usual. And thank you everybody for staying on the call. Feel free to sign off, Professor Howard, but I wanted to share with all of you, this is a series of 4 mock law classes. So we have 3 more on the calendar. We also have on May 22nd, a career panel where I'm super excited. One of our panelists is zooming in from Dubai. He set up being a law director in Dubai. And then we have 3 of our alums joining us in person here on campus. So we welcome you to come on campus and meet everybody here, meet each other, meet other incoming students on May 22nd from 6 to 8 p.m. And of course, we welcome you to our upcoming additional mock law classes. And at that point, I'll just open it up to anybody. Do you have any questions about applying or the LSAT or what to expect? And no question is too small or too big. If I can't answer it, I'll help you figure out who could answer it for you.
So if you applied and your application was not accepted because your LSAT score was too low and your GPA, can you reapply, and what do they look at when you reapply?
Sure. So sometimes it takes applying 2, 3, or 4 times. I think that in all the 17 years I've been here, somebody applied maybe 8 times and finally got in. So what they look for is
hope for me.
Yes, they definitely want to see your grit, your determination, your follow through. And sometimes that is seen by you taking their advice and retaking the LSAT. So say you apply and you don't get in the first time, and they've asked you to retake the LSAT so they can try to assess whether or not they think you're going to be successful in law school. Take it again and don't feel badly that you're being asked to do that, and take it again, because it shows your determination. It shows that I want this. And at some point they're going to, they're trying to be fiscally responsible to our students. They don't want to take someone's tuition money if they don't think you're going to be successful. So they're truly trying to be responsible to you. If your LSAT score is right on the cusp, the LSAT scores range from a 120 as a 0 to 180 as a perfect score. We like to see people get in the 50th percentile, which is approximately around a 150. If you get into the 140s, I would still complete your application and see if you get in. Obviously, the 145 to 149 range, you have a better chance of being admitted. If you're in the lower 140 range and you don't get in, you can also try another tactic where you appeal their decision and you write a well-crafted letter addressing why you think you should be admitted. Maybe you're going to address your work experience or your maturity and that you want to take accountability for this entrance into law school. So
Thank you.
Yeah. Any
Quick
other
question.
questions?
Yeah, I get the emails, and I thought I saw an email. Hi, Dan. I thought I saw an
Hi.
email saying the waiving the application fee before which date, and what date was that?
Yeah, we currently have the applications fees waived. So if you started your application, there's no application fee with San Joaquin
Okay.
College of Law. So
Okay, got it.
we haven't closed it. It's just a pre-populated fee waiver. So we're realize people are, it's, you know, expensive to apply to schools and graduate schools. So we currently, and I don't know that they're going to remove it.
Thank you.
Thanks for asking. Anything else, Johnny?
No, that's it.
Anybody else? Anybody else? Anybody else
I have
taking?
a, Hi,
Okay.
Dan. I have a quick question. Hi, Michael. Hi.
Hi, there you are.
Hi. Nice to see you in person. You helped me
Yes,
on a lot of my emails, so thank you. As incoming student, classes are going to be live or asynchronous? Probably live, I assume, right?
Oh, you mean when you're actually a law student?
Yes.
Yeah, what's really exciting, Michael, is we have a synchronous learning option. Unlike other schools where you watch recordings and the bar pass rate is very low, we're very proud of the fact that we're one of very few, if not only, schools offering synchronous learning where you're going to be in
The synchronous. Okay.
So it is synchronous with the in-person, the remote people are up on a big screen joining us, and we're trying to give them as much of an in-person experience as possible. So we believe the in-person experience is a bit superior to prepare you to become a lawyer or a judge. So we really encourage the in-person, but we've done everything we possibly can to make it feel as much for our remote learners as that they are sitting in the classroom with the big screen. You're going to be called on, the whole thing. So, and you can choose at the start of every semester and each class individually which ones you want to be remote or which ones you want to be in person. And you could change it up throughout your 3 or 4 years that you're here.
Okay.
Danielle, I think you're muted if that's you talking. Thank you, Michael. Nice to meet you.
Nice to meet you. My pleasure. Thank you for everything.
Yeah, awesome.
Thank you,
Danielle,
thank you.
were you talking? I don't know. Or did I miss somebody? Maybe not. Anyway, I have any more questions from anybody? I'm happy to help.
Hi, Diane. Yes, I have a question. I believe in the email about the career panel that's upcoming, there's also an option to register for the remaining mock classes of this 4-class series. Is that something we can do all at once, or will it be individually for each one?
Right now, there's only one more that's up, and that is Dean Tender.
Oh, okay.
So you could register for that one, and probably in the next day or two, our IT team will add the other two.
Okay.
I could tell you the dates. They probably came in an email to you guys. Let me look from my day planner.
Yes. You know what? I just found the email, but thank you so much.
Okay,
Yes.
perfect. Yeah.
Great.
Can you tell us what the dates are in case somebody?
Yes, I can. I have that the next one is on Thursday, May 15th, 12 to 1, and then May 27th and June 9th, and it looks like they're all 12 to 1.
Perfect. Thank you so much. Yes.
Thank you.
Any other questions? It's so exciting that you're all on the call. You're all welcome to, communicate in the chat if you want to. By show of hands, maybe who is taking the June LSAT by show of hands? I guess not everybody's on video, but you can hit the hand icon. So I don't see anybody. So maybe you've all taken the LSAT. If you haven't yet taken the LSAT and you want to start law school August 11th is our first day, you can try to get into law school with a graduate record exam because that's offered on demand. So you could still try to get into law school if you haven't registered for the June LSAT. Yeah.
Miss Still, what
Yes.
if you score lower than your LSAT score, which was low?
Second time around.
Yeah.
Yeah, it's giving you more information than it's giving us. That, you know, usually when somebody doesn't score over that 140 hump, law school is going to be hard. It's going to be more challenging. So, and that's why they use that as one of the measurement tools to decide if you're going to be successful. But you can also try, Lucy, taking the GRE and seeing if that's a better fit for you and see if that you score high enough, because there is a small percentage of people who just cannot do well in that LSAT, and they did well in law school. They appealed the decision and they wrote a very well written appeal and provided other reasons why they think they should be given the chance. And they owned that accountability financially, and they gave them a chance. So, and I remember somebody to my mind who was in the high 130s, and she ended up being top of the class. So sometimes that LSAT's not the best predictor.
I agree with you because I'm a special ed teacher and I know that people learn differently. And I know some people get a lot of anxiety. I'm
Yeah.
not making excuses for me, but I know that I'm looking at the class, a lot of sharp students out there, you know.
Yeah.
So
Yeah, it's awesome.
anyway, thank
Well,
you.
yeah, we have everyone from, you know, fresh out of college, traditional students coming in, and our all the way through students, you know, through their 50s, 60s, and 70s sometimes. So I love Michael Elder, one of our alums. He went to law school in his 50s, and he said, Diane, the great thing about graduating as attorney in my 50s and starting my practice in my 50s is when I went before the judge and I went before the jury, no one ever thought I was a rookie.
Oh, wow. There's hope for me.
Yeah.
I'm the only grandma in the class.
No, there's some more mature students. And the other thing I like to share, one of our professors, Larry Artinian, he's the contracts professor in the evening. You know, he tells a story about how a young student knocks on his door and says, Professor Artinian, here I am in class with all these older students who have so many life experiences and know how to read contracts and understand things. And here I am with them. How do I have a chance? They're so much more mature and knowledgeable to me. And Professor Artinian pats him on the back and says, you know, hang in there, you're going to be just fine. And then 2 minutes later, he gets a knock on the door and it's an older student saying, here I am in class with all these young whippersnappers who know exactly what they're doing. And I'm fresh out of college, and how am I ever going to, you know, keep up? And I think we all have that imposter syndrome where we think I can't do it. And as Professor Howard said, don't underestimate yourself. You know, get in there, apply yourself, work hard. And, you know, they do disqualify folks who are not at a benchmark after the first semester, mainly because we don't want you to go into $20,000 debt. You know, if you're not cutting the mustard at the end of the first semester, we do lose students. And then we will lose students at the end of the first year. So really, you don't want to underestimate that first year. So if any of you have the option to cut back your workload or get a job or some flexibility with your employer to flex your time, particularly before finals, just don't underestimate that first year. The first year is the hardest. You're trying to figure it out. Our professors are amazing. You just set up the office hours. Don't be afraid that your tuition is paying their salary. That's why we're all here. So go ask them to read your practice exams and give you feedback. You could even take practice exams. Jody Howard is amazing, who you just met. She set up a bunch of workshops to help you succeed. And I'm going to be emailing folks and pointing you in the direction of those just so that you can even start watching them if you like. We want you to be successful. And San Joaquin College of Law is amazing. All of our graduating class in last year, 2024, over 74% of them passed the bar exam on their first try. Those students started at the peak of the pandemic. You know, the pandemic hit in 2020 of spring. They started in August. They joined our program without even setting foot in the building. So they did a large share of their education online, and 74% of them passed the bar the first time. So other questions? I know you must have questions. Don't hesitate. Anybody? Karan, did you have a question?
Yes, I do. Will this recording for today's meeting be available to us if we
Oh,
wanted
probably
access?
so. It just reminded me I
Okay.
never get stopped.